think it was in July 2005 when the committee was set up. And this committee was set up because that was while I was Attorney General, because of my background in arbitration and the fact that I knew, even before becoming Attorney General, that the old Act of 1988 was no longer up to date. As you recall, that act was made based on the Uncitral Model Law of 85. And Uncitral had done an amendment before 2005. And even now, they've done 2 other amendments. And so we needed to bring the law up to date along with best practices, because Nigeria was making a case for foreign direct investments. At that time, the then president had initiated some very positive moves on debt forgiveness. Also, crying for foreign direct investment, what you call FDI, to come to Nigeria. And if you want investors to come, the first thing they're going to look at is your legal regime for resolving disputes, in case there are disputes. There will be disputes anyway. And so I felt that we needed to put in a new act which will take into cognizance the amendment to the Uncitral Model and also take into cognizance best practices in other parts of the world as of that date. Don't forget, we already had the English Arbitration Act of 1996, which came in just about 9 years before then. So this was the motivation that made me to set up the committee. And the committee was headed by the late Dr. Orojo SAN. He was a past president of the Chartered Institute of Arbitrators, Nigerian branch of the UK branch. And then he was a past Director General of the law school. And then I think he was the first Nigerian Director General of the law school. He was a past Chief Judge of Ondo State and very erudite jurist. So he was the chairman of the committee. And the committee was made up of very, very eminent personalities and arbitrators. Too numerous to mention now. Chief Mrs. 𝐄𝐩𝐢𝐬𝐿, Chief Bola Akinola, the current president of the institute, Mrs. 𝐏𝐫𝐸𝐬𝐿, and Mrs. Rosewife, so many, Mr. Belgorem, Mr. 𝐂𝐩𝐢𝐬𝐿, and lots of practitioners in the arbitration component of Nigeria. So this committee was set up, and they were supposed to come up with a new arbitration bill which will be sent to the National Assembly. And at the end of the day, they came up with 2 bills, one for the federal, and the second one for the states, because we wanted a guide for the states as well, because there had been a dichotomy as to whether or not the states could set up their own law. And I'll dwell on this much later. The 2 bills, like I was just telling you a while ago now, were supposed to be for federal and the states. That of federal, there's no problem about that, because Nigeria is a sovereign country and we need a law which will govern trade and disputes between parties in Nigeria and outside Nigeria. Now, if you look at item 62A and item 68 of the second schedule to the 1999 Constitution, Schedule 2, it talks about trade and commerce being in the exclusive legislative list. So to that extent, if you have a party that has a dispute between somebody in Nigeria and outside, it means that only the federal law will govern it. But if you have a dispute between somebody in one state in Nigeria and another state, or between two states, then the arbitration law of that particular state, as it were, will govern it. So there's that dichotomy. And some people are of a different view that the state government can legislate on Arbitration Act itself and have their own act, like the Federal Act.
Yes.
But I was of the view that we can only have one Arbitration Act. The states can have arbitration laws, which they're empowered to do, because trade and commerce is in the exclusive list. So the states cannot legislate on the act, as it were, but they can have laws which will govern arbitration between parties within their states or between their state and another state in Nigeria. So that is the difference. So what we did was the committee came up with these two bills, one for federal and one for state, and that of the states was supposed to guide other states for them to adopt that with some modifications,
when they're making their own
law. And happily to date, I think Lagos, Delta, and Rivers have done that. That's a good question. Well, let me say, first and foremost, I think it was an executive bill which was sent by the executive to the National Assembly. As you know, bills are two ways, either executive bill or private members. But I think the National Assembly was just lethargic. They didn't appreciate the need or urgency for such a law, and they were just lethargic, and each time they worked on it, before the end of the tenure of that, the life of that assembly, they don't get to pass it. So a new assembly will start all over again. And between 2006 to date, we've had how many assemblies now? We had one 2007 to 11, 11 to 15, 15 to 19, 19 to 23. So we had 4. So that means they just kept considering it, but somehow being lethargic and not appreciating the urgency.
We held a retreat, I think 17th of October 2015 or thereabout, I can't remember the year. And one of the main things we interrogated was whether to replace conciliation with mediation. But at the end of the day, we just decided to leave conciliation. And then the bill went to the National Assembly. It was passed by the Senate. And I recall that it was the 7th of August 2017 when the Singapore Convention opened up for signature. And on that very first day, Nigeria was one of the first countries to sign the convention. And then we went back to the drawing board and asked ourselves that if there's now a convention that has dealt with one of the challenges with enforcing cross-border execution of international settlement agreements resulting from mediation, why then should we have a law that is going to be current, and then we have conciliation as a provision in it? And then we reminded ourselves of the conversations we had that even in conciliation, nobody could come up with a single instance where conciliation provisions have been used in any pre-arbitration proceedings. So we then decided to withdraw that bill from the National Assembly, even though it had been passed by Senate, and replace the conciliation provisions with mediation. And when we did that, we predicated the mediation provisions on the UNCITRAL model law on international commercial mediation. And even though that model law is expected to deal with international commercial mediation, it also gives you the opportunity to put in provisions that would enable the same provisions to be used to deal with domestic disputes. So what we have in the Arbitration and Mediation Act deals not only with international mediation, but also domestic mediation. That is one of the reasons why it took so long for that bill to be passed, because after we did the overhaul of the conciliation into mediation, we had to return it to the National Assembly. The House of Representatives passed it, and then it had to go back to the Senate. And then the Senate had to pass it again the second time. Let me share my first encounter with a multi-door courthouse. The USAID had invited about, I think, 25 of us in 1990. And at that time, I was a politician. And we had this women in the political process engagement in Washington. And we visited some courts, and I heard about multi-door courthouse for the first time. And I was quite excited that you mean there's a framework where people can resolve their disputes without going to courts. And he told me about Mr. 𝐏𝐻𝐢𝐬𝐿, who is doing something about it in Nigeria. So I met with Mr. 𝐏𝐻𝐢𝐬𝐿, and when the multi-door courthouse started, it was very clear from the beginning that one of its main areas is to focus on mediation and take control of resolving the disputes away from a third party and put it in the hands of the parties. And since then, I think if you ask the director of the multi-door courthouse, she'll tell you that 90% of their work is on mediation. And why does it work? Because the reluctance, or would I say, I wouldn't even say the reluctance, the late buying of many lawyers came from the fact that they didn't understand the values and the impact of mediation. In the first instance, you have cases that have been in court for 20 years. I keep giving the case of a case in which Shell was a party, and one of my young friends, Mr. Isaiah Bozimo, had not been born when that case started. And his father started the case at the High Court, took it to the Court of Appeal, and it was Isaiah Bozimo, who was not born when that case started, who handled the case at the Supreme Court. So you can just imagine how many years that case had taken. Now, let me give you another scenario where a former vice president of Nigeria had been in court on a matter for 19 years. And then the judge suggested mediation to him. He was reluctant. It took quite a lot of persuasion to get him to agree to mediation, and he actually attended the mediation in person. And a 19-year-old case was settled in less than a day, and he was completely surprised. And he said, where has this process been? So that is one of the major benefits. I have cases in my law firm that have been going on for over 10 years, 15 years. And what men of commerce, what businessmen want, is not to devote their time, the management, the executive time that they should spend on their businesses, on generating revenue and income for their business, in court, sitting in court, getting adjournments from 1 month for, I mean, you can be at a preliminary stage for 3-4 years. And that is not what the average businessman wants. That's not what the young entrepreneurs who are just starting off in their businesses, that's not what they want. That is not what the international businessmen want. So mediation is not just fast. Second, it puts control of the dispute resolution in the hands of the parties. Unlike adversarial dispute resolution mechanism, where somebody decides that this party has won and that party has lost, what mediation tries to do is to get the parties to come up with solutions that work for them. Solutions that they have themselves crafted. And solutions that means that at the end of the day, there may be no need for any enforcement proceedings to be held because the solutions were not imposed on them. More importantly, the role of the mediator is just to facilitate communication, because by the time a dispute degenerates to a level where it is being litigated, parties are no longer talking to one another. And everybody is very staunchly supporting and defending his position. And then through skills that a trained mediator, because I mean, some people call themselves mediators who are not actually trained mediators, help bring the parties to the realization that they need to come to a win-win situation. And at the end of the day, this adage, which I grew up knowing as a young Whig, in fact, before I read law, I've heard that Yoruba adage, which is to the effect that you don't go to court and come out of the court as friends. And the same thing goes for any other adversarial dispute resolution mechanisms. As long as one party loses in that mechanism, the likelihood of the parties coming together to do any other form of business is not going to happen. So, and that's one of the benefits of mediation. Parties resolve the dispute themselves and they continue business if they want to. And then another, I know that is important, but another critical importance is the cost. I'm a chartered mediator, arbitrator. I'm a CEDA accredited mediator. And I know how much I earn from arbitration and how much I earn from mediation. You cannot compare them at all. But mediation, because it doesn't take as long as arbitration, is more cost effective. And when I read some of the agreements that young entrepreneurs go into, and I read their dispute resolution clauses, sometimes I feel like weeping, because many of them just, and that is perhaps because of the limitation of the knowledge of the young lawyers they use, they just go straight into arbitration. And when the process needs to be kicked in, many of them cannot afford to arbitrate the dispute. And at the end of the day, they lose out. I say to people that new act is a gift to Nigeria. A gift because even as I sit here, I read the act every day, and new things just keep popping out to my mind that, oh, you mean we put this there? You mean this is a provision there? Because if you recall the genesis of the bill, the first draft of that bill was put together by the Orojo Committee. And the person who wrote that first draft is Mr. 𝐞𝐻𝐢𝐴𝐻𝐿 SAN. And that was in 2005. That is 18 years down the line. So what we did when we took over about 9 years ago was just to upscale it and bring the provisions in conformity with current best practices. So anytime I open it, I just see new things, and I'm so fascinated by the provisions that I read. In terms of your question, let me just go straight to your question. I can say, if you read section 79, it clearly says that a mediator shall not, and this is a mandatory provision, shall not act as an arbitrator. And the importance of that is underscored by the fact that some people believe that as a mediator, you can also tell them who is right or wrong during the mediation process. No, that is not the role of a mediator. As I said earlier, the mediator is just to facilitate communication in such a way that is productive for those parties to be able to come up with win-win resolution of the dispute. So the law is very clear about that. You shall not act as an arbitrator. Another provision of significance is in section 780, which says that, and it's also another mandatory provision with very limited exceptions, that as long as there is an undertaking entered into by the parties to mediate, you must comply with that undertaking before you go for any other adversarial means. And if you look at the arbitration proceedings rules in the new Act, it is one of the gifts in the Act, and which is to the effect that we don't want cases to stay too long, arbitration related cases to stay too long in courts. So if you go to court, this section is more like the arbitration equivalent of section 5 of the Act, which is that the court will stay proceedings. And we expect any arbitral tribunal to also stay proceedings if there is this undertaking reflected in section 80, as long as there's an undertaking by the parties to mediate. Mediation must take place. Now, and this is critical, section 77 deals with the confidentiality protocol of the Mediation Act, and all communication, all the documents that have been produced for the purposes of the mediation cannot be used in any adversarial means of dispute resolution. The arbitrator, anybody who has supported the arbitrator, the institutions and so on, cannot be compelled to come and give evidence of what transpired during the mediation process, unless there's a law that makes it mandatory for them to be called upon. They cannot be called upon to come and give evidence. And you cannot mandate them, you cannot use the documents, but that is not to say that if you have produced a document in a mediation proceeding, you cannot use that document for arbitration. For example, the contract between the parties may have been brought to the mediation proceedings. That does not mean that you cannot take that same contract to arbitration if mediation fails. Yes, it is something I've encountered, and I just smile, and it's because sometimes the lawyers don't find a role for themselves in mediation. So I try to coach them about the roles they can play. As a mediator, if you expect the parties to prepare a summary of their case, that's usually prepared by their lawyers. And it is submitted because the parties would not want to prepare those kind of documents. Their lawyer would prepare it. Even during the mediation proceedings, the lawyer can sit in and advise their parties. Because it is a party-driven process, in my own mediations, I try to keep the role of the lawyers to a minimum as much as possible. But you will find clients still consulting with their solicitors or their counsel during the mediation proceedings. That is fine. That is a role for lawyers. And more importantly, critically, after the entire mediation process, if the parties are able to settle, the mediator would work with their counsel to come up with a mediator settlement agreement, which is major. And in fact, sometimes we spend more time crafting that document than we spent during the mediation exercise itself. But it's all to the good. And one thing that I also want to bring to the fore is that the new law on the remuneration of lawyers in Nigeria has stated very clearly that when you get a brief, you must enter into terms of engagement with your client. It can be a term of the client of that terms of engagement letter, that if this case settles, whether by mediation or private negotiation between the parties, this is how much your fees will be. So nothing precludes lawyers from earning their fees. I've worked with lawyers. In fact, I recall a core litigation lawyer who was in his law firm was in a transaction with us, and he happened to be part of the team. And he was vehemently opposed to the mediation provision we insisted should be in the multi-tier dispute resolution clause. And he and I met about 2-3 years ago, and he was like, Mrs. Roberts, I'm now sold on mediation. And he gave me the reasons why he believes that mediation could work. And I can assure you it does work.
If you have a dispute with no connecting factor to Nigeria, so non-Nigerian parties, non-Nigerian contracts, non-Nigerian just everything external, no connecting factors, will they choose to come to Nigeria to arbitrate? More likely than not, the answer will be no.